Hi, I'm Sam Butcher, the owner and founder of Butcher Elder Law. What I'd like to discuss with you in this video is basic estate planning. Why does anyone need an estate plan anyway? And the answer is control. It all comes down to control. Nobody ever wants to lose control, and yet we meet with people in our office regularly who have lost this. Why did they lose control? The answer is because they failed to plan when they could plan. There are basically two positions in which people can plan: vertical and horizontal. And it's a whole lot better to be planning when you're in the vertical position, because when you're horizontal, you're either staring at the ceiling tiles in a hospital or nursing home room, or you've simply waited too late to plan. All estate planning comes down to these three things: who's in control, who has access, and who gets the benefit. You know, a lot of people think that all estate planning is about is who gets your stuff when you die. They are seriously mistaken. When we sit down with clients to plan, we plan for 3 stages, and those stages are these: when you're alive and well, when your health fails, and what happens after you die. So to begin with, when you're alive and well, you're in control, right? It's easy. But what happens if you've suffered a medical emergency, or you suffer an illness or disease? Now who's in control? Gets a little bit trickier, doesn't it? Okay, because you don't have the ability to articulate instructions and take care of your own business in the way that you did when you were alive and well. And what happens after you die? Now who's in control? Who's in control after you pass away? Is it your wife? Is there somebody else in the picture? Is there a new spouse? What kind of condition is your wife in at that point? So we don't know the answer to all these things, but we can consider what we need to do to plan so that when something happens, because something's going to happen, something happens to everybody, you're going to still be in control because you took the time to plan when you could plan. So what is your estate? Well, you know, it's everything you own. It's your stocks, your bonds, your real estate, your mutual funds, any other investments you have. But what's the most important part of your estate? Well, in our firm, we believe the most important part of your estate is you. That's the foundation. And you know what we tell our clients? This is the one time when it's okay to put yourself first, because you really can't think about helping anyone else unless your own house is intact. You know, this is like, you know, the instruction you receive from the flight attendant before the plane takes off. Should the cabin lose pressure, a mask will come down. Please put your own mask on first before you try to assist the person sitting next to you. The same is true for estate planning. Take care of your stuff first. Next, we look at what you can do for your family. And then we talk about what we can do to protect your stuff. A comprehensive estate plan doesn't just include a will or a trust. It includes powers of attorney, a healthcare power of attorney, a living will, a financial power of attorney. These are all documents that absolutely must be included in a comprehensive estate plan. And what about a will or a trust? Which do you need? I have no idea. That's not a question that I can answer until I sit down with clients and they let me into their world, and then we can offer options and make recommendations. But I can tell you this: you have to know and understand the law in order for your estate plan to work the way you want it to work when the time comes that it needs to work for you. What do I mean by this? Well, let's say that you've created a world-class will and a world-class revocable living trust, the best money can buy, and you think you know exactly what's going to happen and who's going to get your stuff when you die. Well, you may be surprised to learn that because of joint account ownership or beneficiary designations, all of those types of legal ownership will trump your estate plan. So it could come to pass that that world-class will or trust has nothing to do with how your story is going to play out, because your son got everything since he was the in-town kid and you put his name on the bank account just for ease in banking as you grew older. Or you had another child or another individual's name on a life insurance policy as beneficiary, or you had some different beneficiary designation on an annuity or another one of your assets. So all of these things can trump your estate plan, and it's important to know and understand how ownership is going to be transferred, and it's equally important to know who has access to these assets of yours in the event that you're not dead, that your health has failed, and now in order to care for you and to continue to care for your loved ones, we need to be able to access your wealth. You may think, well, you know, my wife is the beneficiary of my IRA or 401k, and most of my wealth is tied up in those retirement funds. But she'll be well protected, or he'll be well protected. Well, what happens if you're not dead? Those benefits aren't available to your spouse, and yet those benefits may be the only source of revenue that's going to help pay for in-home care, so that in the event of a medical emergency or a tragedy of some kind, your spouse can bring you back home, because after all, that's where you want to be. You don't want to be relegated to a long-term care facility somewhere, a nursing home, if you don't have to be. So who's going to have access to those funds? And that leads to the need for a very comprehensive power of attorney. You know, we meet with a lot of people who come in with a power of attorney, but rarely does the power of attorney that they have contain all of the power and authority that they need to act in certain situations. We like to make sure our clients have a very, very expansive power of attorney, but we also want to make sure that power of attorney is tied into some instructions, so that their agent has to act in conformity with what is in our client's estate plan. There's another very important reason to plan, and that reason is that if you don't plan, guess what? The state has a plan for you, and that state's plan can be costly and cumbersome and create a great deal of difficulty for your family when your health fails or when you're gone. So let's say, for instance, that you've suffered a medical emergency of some kind, as a result of which you cannot make your own decisions. If you don't have an effective healthcare power of attorney and a durable financial power of attorney, your loved ones may be forced to go to the courthouse and apply for a guardianship over you, so that they can continue to care for you and make decisions about who's going to care for you and where you're going to be cared for, and to continue to engage in financial transactions because you're unable to do those things on your own. And a guardianship proceeding is adversarial in nature. It's time-consuming. It involves attorney fees and court costs, and it all could have been avoided with a very comprehensive healthcare power of attorney and durable financial power of attorney, if only the individual had taken time to plan before something happened. If you'd like to find out more information, please give us a call. We'd be happy to sit down with you and discuss your own personal situation and tell you how you can remain in control when something happens. Thank you very much.